I'm Ben Meiselas from the MeidasTouch network. I want to analyze with you a document that was filed by the Department of Justice over the weekend in the Mar-A-Lago search warrant matter. You know, the matter where Donald Trump stole tens of thousands of records from the government and then filed a motion for judicial oversight back in August and got appointed Judge Eileen Cannon, someone who he actually appointed to become a federal judge, and she granted this motion for judicial oversight and improperly asserted equitable jurisdiction, and the 11th Circuit ruled that she shouldn't have asserted equitable jurisdiction regarding the top secret classified records and returned those to the Department of Justice. And then there's an expedited appeal that the 11th Circuit ordered, where I've predicted very confidently the 11th Circuit Court of Appeals is going to rule that Judge Eileen Cannon should have never asserted equitable jurisdiction in the first place and appointed the special master. And by the way, the special master is completely pissed off with Trump and his lawyers and knows that Trump and his lawyers is playing games. And at all of these hearings that take place before the special master goes to Trump's lawyers. Where's the beef? What are the issues here? Like, what are you even claiming? You're claiming things are personal, and you're claiming things are also executive privilege against the actual executive branch, and it's the executive branch's documents, and you think you can just steal records and then just claim they're yours. And so, as I said, the 11th Circuit Court of Appeals, I think by end of November, early to mid-December, it depends whenever they set oral argument, but they're going to rule that Judge Eileen Cannon should have not started that process at all in the first place. But the process still is taking place, at least with respect to the 11,000 other government documents, until the Court of Appeals finally makes its ruling. And so the parties have been presenting the various documents to the special master for adjudication. And Trump's just made the most absurd claims. I mean, he claims that, this is literally his claim, and I've done another video on this, but he claims that he designated the government records, the presidential records, personal, because when he packed the documents and stole them and sent them to Mar-A-Lago, by doing that, he asserted, without actually making an assertion, but by packing the documents, then he said they're mine, and that therefore they lose the status as a presidential record and become a personal record. And then he argues, well, then even if you don't find it's a personal record, I am still asserting executive privilege, even though I'm not the president, but I'm making an executive privilege claim, to which the Department of Justice has said in a filing, executive privilege is not a privilege for an individual. It is a privilege to protect the institution of the presidency, to protect the institution of the executive. And the current executive has not claimed executive privilege. In fact, there's a compelling need in a criminal investigation taking place right now into your criminal conduct, Donald Trump, in stealing our nation's secrets and other government records which don't belong to you. But Trump's basically made this whole process a complete mess. And you really see this in this document that was filed November 12th, 2022. And this is the process that the government and Trump and everyone has to now kind of abide by, where they are showing the special master this Excel worksheet. Here, I'll put this Excel worksheet up here too, about, identifiers are the documents at issue, and the Bates numbers are the specific Bates number identifiers of the documents at issue. And then you go to the plaintiff. Here, because Trump filed this lawsuit, is Trump. And so that's plaintiff, defendant, government. And then you see on the right, there's like a dispute, and then like what the dispute is. Then the special master ultimately will make the ruling regarding the classification, whether there's a privilege or not a privilege. And by the way, there's no privilege to any of these records. There's no basis for Trump to claim them as personal. That's what's going to happen. There's a hearing on December 1st that I just can't wait for, because the special master, Judge Raymond Dearie, is just going to excoriate Trump's lawyers. I have no doubt about it, for just these completely frivolous claims that these records are personal because he wrapped them up in bubble tape and then bubble wrap and then sent them to Mar-A-Lago. So the purpose of what this document was to basically let the judge know that this is the Excel spreadsheet that the parties basically agreed on to flag the potential disputes over their arguments regarding each document. Look, I could tell you what the Department of Justice is going to put for each of their arguments. They're going to say, these are all documents that belong to the government, return them. And Trump's going to make these arguments. They're both personal and executive privilege at the same time because he shipped them, so therefore they make them personal. But if you dig deep into this argument, I want to give a special shout out to The Guardian and Hugo Lowell, who did a very, very, very good job digging into this issue as well and these documents. But if you go to the very last two paragraphs of this document, so let's go to page 7 and 8. And so at the bottom of page 7, it talks about email messages that were in Trump's office, and that these email messages and other messages and paperwork were emails and paperwork from after when Trump left office. And those were mixed in Trump's office with top secret classified records, our highest classification of top secret records in the country, which is evidence, the intermingling is evidence that Trump was using or utilizing the top secret records recently for improper purposes. These weren't just documents that were locked in storage in Mar-A-Lago. They were actually mixed with current records that Trump was utilizing as well. And let's just take a look at what it says first. And it says, the printed email messages postdates plaintiff's term. Plaintiff here is Trump. In office and is therefore personal. Because the correspondence postdates plaintiff's administration, the content cannot be in furtherance of official duties and therefore cannot be subject to a claim of executive privilege. In other words, Trump is claiming that documents that were created after he was the president are subject to executive privilege, and the Department of Justice is saying that's nonsense. Then he goes on to, the Department of Justice goes on to talk about this batch of records and goes, this document is a compilation that includes 3 documents that postdate after plaintiff's term in office and 2 classified cover sheets, one secret and the other confidential. Because plaintiff can only have received the documents bearing classification markings in his capacity as president, the entire mixed document is a presidential record. So what they're saying here is that this compilation includes documents that postdate his term, but also includes these records that predate. These are classified records that took place during his term. Because plaintiff can only have received the classified documents in his capacity as president, this entire batch of documents has to be presidential records. But you see, he's intermingling the top secret with other records that he's using for some purpose. Then it goes on to say, besides the classified cover sheets, which were inserted by the FBI in lieu of the actual documents, none of the remaining communications in the document are confidential presidential communications that might be subject to a claim of executive privilege. 3 communications are from a book author, a religious leader, and a pollster. The first 2 cannot be characterized as presidential advisors, and all 3 are either dated or by content occurred after plaintiff's administration ended. And they go, thank you for your consideration to the judge. And I think they leave with that, which is very powerful. Again, what we see here is Trump intermingling top secret records with these other communications, one from a book author, another from a religious leader, another from a pollster. And he's claiming that those documents are also executive privilege or are personal at the same time. And the government saying, how could those aren't executive privilege? Those documents, one, are nothing to do with being the president, and they're created after the fact. But you're intermingling those documents with documents that clearly are top secret classified records and thus are presidential records. You can't claim that you own those. And Trump's making all these conflicting claims, but that is kind of key evidence that the Department of Justice in their criminal investigation is no doubt looking at. And the fact that you have intermingling of documents, both top secret documents and current contemporaneous records together as opposed to just in storage, but just storing it is unlawful, shows a use of it, shows the intent element. And no doubt that is an important part of what is currently being investigated by the Department of Justice. The other updates, which of course we've reported here on the MeidasTouch network, is that Kash Patel, one of Donald Trump's former top advisors when Trump was president, who worked as the chief of staff to the Secretary of Defense, who was put in that position to try to overthrow the free and fair elections, and then who was designated to work with the National Archives after Trump left office, but basically just bragged that Donald Trump declassified all the Russia documents and all these records related to our national secrets. Well, Kash Patel was given a limited use immunity, meaning he was given immunity only with respect to what he testifies to before the grand jury, because he invoked the Fifth Amendment, and to compel his testimony, if you grant limited derivative use immunity, he can't be prosecuted on what he says to the grand jury or what's derived from the testimony, but he still can be prosecuted for perjury, and he still can be prosecuted for things the government knows about him independent of his testimony or what they've learned from his testimony. So that's the biggest update we have here, and we will keep you posted with more information here on the MeidasTouch network. I'm Ben Meiselas. Make sure you hit the subscribe button. We're on our way to 1 million subscribers thanks to your support. And in addition, please check us out at Patreon. Go to patreon.com/MeidasTouch, patreon.com/MeidasTouch, and consider becoming a patron of the MeidasTouch network. Appreciate you.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.MeidasTouch.com. That's store.MeidasTouch.com.